Even as many are still assessing the Kyle Rittenhouse trial verdict, another closely watched legal case is expected to go to the jury tomorrow. That's involving the three men charged with the murder of Ahmaud Arbery in Georgia. The two homicide trials are different in many ways, but as William Brangham reports, both touch on fundamental issues for the country.
Claims of self-defense are central to the defense in both of these high-profile cases. But what exactly constitutes a self-defense claim? When can you legally use lethal force against another person? Stephen Saltzberg is a law professor at George Washington University. In his career, he has served as both a prosecutor for the Department of Justice as well as a defense attorney. Professor Saltzberg, very good to have you on the NewsHour. Obviously, these cases are both very different, but as I mentioned, they both have central to their defense a claim of self-defense. When someone makes that claim, what in essence are they arguing?
They're arguing that they have a right under the law to protect themselves when they reasonably believe that their own life is in danger, and that if they don't act, they could in fact be killed.
So there's, as I mentioned, there's some similarities in these cases. Both of the shooters made that claim that they felt that they were threatened and had to use deadly force. But there's also meaningful differences in the two cases. Could you explain those differences?
Sure. They're actually, the similarities in some ways outweigh the differences. But in both instances, Kyle Rittenhouse injected himself into a demonstration knowing there could be violence. He brought a high-powered rifle with him and said he did it for self-protection, even though he didn't expect to use it, he said. But he had it there because he knew he might have to. And then he got into a situation in which he thought that the first of his victims was trying to take away that gun. And if that happened, the victim would use it against him. And so he fired. And he continued to fire, kill one more person and wound another. All because he said he feared for his own life. In the Arbery case, the shooter, Mr. McMichael, who testified in the case, basically said that he was trying to make a citizen's arrest, which came out for the first time really at trial, and that in the very end, when he struggled with Mr. Arbery, they were both struggling for a gun, and Mr. McMichael feared that if Mr. Arbery got the weapon, McMichael would be the one who would be shot. And so he too feared for his own life.
So it sounds like in both of these cases, it's the person who uses the force. It's their testimony that says, I felt threatened, thus I acted.
They do not have to testify in their own defense. But when they raise self-defense as a defense, it's much harder to make out that kind of a defense if you don't get on the stand and explain how scared you really were. And that's why at least the shooters in both cases, Mr. Rittenhouse and Mr. McMichael, both chose to testify.
Does the circumstances in which that got you into those circumstances matter at all? Does it matter that you're a teenager and took a semi-automatic weapon and went to what was a violent protest? Does it matter if you were trying to execute a citizen's arrest against someone? Does anything about those circumstances that gets you to the point of a conflict matter in a self-defense case?
If you're the first aggressor, if you put yourself in a position where the person that you shoot is acting because that person really has no choice, you put that person in such danger, you basically can't make out a valid self-defense case. In the Rittenhouse case, he basically said he was there to do good. He was there to protect a car dealership. And so he wasn't trying to do anything wrong, he said. And therefore, when he felt under attack, he could fire. In the Arbery case, the defendant's claim is that they thought that there might have been a burglary and that they were also responding, not intending to put anyone in danger, a mortal danger.
Some people have argued that the Rittenhouse decision, while it may fall under Wisconsin's self-defense claim, that it could create something of a slippery slope where more people feel emboldened to go into tricky, potentially violent circumstances armed, knowing that the law has their back in some way. Do you agree that that's an issue, a concern?
I regret to say that I do. My belief is that the Rittenhouse verdict is going to have ramifications regardless of what happens in the Arbery case. And that means there are more people who are gonna say, I'm gonna be like Kyle Rittenhouse. I'm gonna go protect the community, and if I have to shoot somebody to do it, I will. I don't think they're gonna say that about Arbery no matter what happens, because it's a very different case. It really looks like 3 white men going after a black jogger. And whatever happens, people will never accept that as being a reasonable thing to do.
All right, Stephen Salzberg at George Washington University, thank you so much for your time.
Thank you.